Court. In this connection, however, the learned counsel further submitted that these observations and remarks about the appellant disclose the extreme hostility and bias entertained on part of the learned trial bench against the appellant. It, however, appears to me that the High Court had found the appellant guilty along with other co-accused on the merits of the evidence adduced in the case. Its findings to that effect were not influenced by any such extraneous consideration. In fact, it was only towards the end of the judgment that this discussion occurs, and the conclusion was drawn in proposing the punishment as stated in paragraph 617 that the appellant was thus liable to deterrent punishment. Although even for this limited purpose, also these observations were not strictly relevant, yet they did not thereby vitiate the order of conviction of the appellant, which was not based on any such extraneous considerations. Now, I can't think of any one of your lordships today writing this paragraph in this particular context.
I need to understand from you, Mr. Khalid Khan, is the court might have given bad judgments, wrong judgments over the years. Then the facility of review was available. So this particular statement that you refer was available, and review could have been filed against that. As I understood from what Mr. Makhdoom said, that when we're looking at this jurisdiction, the one that we're talking about, you're looking at the case in a totally different perspective. You're not looking at the merits, you're not looking at what happened, because that was already settled. You had all the grounds available. You could have raised it in review and settled it. Like this, every bad judgment and every wrong judgment will be open in this case. So it is whether at all there was due process, and that would mean whether at all the judges were independent enough to decide this matter. So this matter was properly adjudicated and fair trial was granted. So all, as I see it, you have to establish before us that either all or one judge was not independent. And that led to a mistrial kind of a argument. But and if you could refer to the material available to establish that the judge was not independent. I mean, I don't understand any other argument. There is no other way that you could say the judgment is wrong unless you show that the bench itself at that time could not possibly have adjudicated the matter fairly without bias. And you'll have to show some material, because it's a big, tall order. You're telling the Supreme Court of Pakistan that they were under pressure and they were deciding a matter which was something that they were under pressure and they could not independently decide the matter. You have to show me that material. But otherwise, we keep on opening.
Khan Sahab, if I, in a way, it may be responding to my learned friend with respect, but one of the due process requirements is, inbuilt in every due process requirement, is that a judge must be free from bias. Now, I think what you are showing to us is this: forget the material that I may show before you. These are judges talking themselves, writing themselves. Are they demonstrating bias or not? And probably that's what you're saying. The other question of pressure is a separate question altogether.
Indeed.
So due process, that may be an additional ground. So indeed, the question before us is, do these words in themselves, these are not words, what I've said subsequently in a judgment or in a book or something like that. I may have forgotten what I've said, but this is what I'm saying in the judgment. Does this demonstrate bias or not? Probably that's it. And if it demonstrates bias, then the due process fair trial requirement may be vitiated or undermined or absolutely done away with. I don't know. So sorry, with respect to my learned colleagues.
So adding to that, I mean, if there are two grounds now, one is that there is a pressure on the bench, and that's totally extraneous to the case. That's one. The other is that the bench, the judges themselves are biased. Now, first of all, that bias issue was taken up in review and must have been sorted out. But still, if you think while deciding the review there was bias, you must have some independent evidence today to establish that there was bias. Because like this, every case could be opened up on the ground of bias.
Very fair.
Review did they touch upon this?
The Supreme Court review was very limited. But
was this aspect, as my learned colleague has pointed out?
Supreme Court
review was it touched upon?
Review was unanimous.
That ground was available to you. You said they were biased, but that ground was not taken.
I'll explain. The judgment of Supreme Court, detailed judgment, addresses all those questions. Now, the review was on a very limited ground, but two submissions. First, as my lord observed, if your lordships would recall, in Asif Ali Zardari case, only one judge was found to be influenced. In Pinisha case, only one judge of the House of Lords was found to be affiliated. That led to annulment of entire judgment. But most interesting, if I may tell your lordships, more grounds that judges were not independent or independently appointed. Majority of them were ad hoc judges who handled Mr. Bhutto.
What were the grounds of review then?
Sir, वो तो बड़े limited ground पे था.
क्या limited ground?
On the merits of the case, not all these.
Merit of 22 का ground आपको available तो था ना? 22 का ground जब.
22 का ground तो है ना?
So they didn't seek
Sir Khalid Javed, can I come to your rescue? Arguing a review before the same bench and saying you are biased would be pretty, maybe not appropriate, because then
No, that's a legal ground. That's a legal ground. You could take it.
Let's hear these.
We are talking about the bias of the Lahore High Court. That you can take before the Supreme Court in review. कि आपने वो जो bias Lahore High Court का था, वो आपने सही तरह नहीं देखा.
Supreme Court ने लिया. जो मैंने 78, 74 paragraphs पढ़े, वो Supreme Court के हैं.
Error हो सकती थी ना उसमें भी.
मतलब अगर वो हो सकता था, Mr. Bhutto would have been alive if the court was that independent. But एक और ground ले रहा हूँ.
Khalid साहब एक second सुन ले, but we are approaching this, and I'm all open for this, that if there is miscarriage of justice, that needs to be rectified. That's the broad principle. The question is how to approach the issue. That's very important. We are all for this, that miscarriage of justice, something needs to be done about miscarriage of justice. I can't live with a history which has a miscarriage of justice. Fair enough. The question next is, in this particular case, what could you take us through the evidence material which would show me that this miscarriage was equal to the judge not being independent? Let's deal with that first and then go on to something. I mean, please identify that this particular judge was not independent. I would go along with you.
First, let's go to the constitution of the benches.
ठीक है.
Paragraph 10 of my submissions, I've addressed this issue. If I may go to para 10D, if you may skip ABC. Supreme Court, I'm narrating the factual background. The appeal was initially heard by 9 judges of Supreme Court from 1st April 78 till 30th July 1978. But on that date, Justice Qaisar Khan retired, who could have but was not appointed as ad hoc judge to continue till conclusion of the appeal. Thereafter, 8 judges heard the appeal, but on 20th November 78, Justice Wahiduddin Ahmed fell ill, leaving 7 judges to decide the appeal. 2 of the judges, comprising the majority of 4, were ad hoc acting judges of Supreme Court. Justice Karam Ilahi Chauhan was acting judge between 27th July 1978 till 13th June 1979. Mr. Bhutto was executed on 4th April 1979.
Before you proceed further,
Sir, only after dismissal of Mr. Bhutto's appeal, he was appointed a judge of Supreme Court.
नहीं वो बात की बात है ना, मगर पैराग्राफ डी में आपने 4 महीने this appeal lasted 4 months.
नहीं सर, 1 साल 4 में, अगला 79 है.
I'll read it again. The appeal was initially heard by 9 judges of the Supreme Court from 1/4/78 till 30/7/78.
79
months.
ना आपने 78 लिखा है.
30 June 79.
नहीं, आपका मैं पढ़ रहा हूँ. You're not reading it yourself correctly. Read what you have written. Paragraph 10D पढ़िए. Paragraph D में पढ़ रहा था. It was heard for 4 months.
Sir, my apology, वो typing mistake है. 79 है. मैं जो जिससे पढ़ रहा हूँ उसमें 79 मैंने ठीक कर लिया.
1 year and 4 months appeal, criminal appeal was heard.
Yes, sir.
Yeah, are you sure on this?
So I'll recheck again.
ये देखें.
I'm just talking about the time spent in hearing a criminal. Is this another record? Because I've never heard of a criminal appeal lasting so long.
So ये अगर page जिस आपने बताया page 53 XX पे है, dates लिखी हुई हैं सारी.
Just first date कौन सी और last date कौन सी?
Date of hearing 1st and 15th April, and this goes on till 23rd December 1978.
23rd December 1978. So,
Yes.
لیکن وہ تو
اتنی
فائنل
ڈیٹ پہ ہیئرنگ ہوئی اپیل کی.
سر یہ ساری اس پہ ڈیٹس پوری لکھی ہوئی ہیں.
9 ججز کا جو کہا اسے ذرا کنفرم کیجیے. آپ نے کہا نا 9 ججز ہیئرنگ سٹارٹ ہوئی, وہ ڈیٹس آپ نے یہ دیے, پھر ایک جج ریٹائر ہو گئے, ایک جج بیمار ہو گئے.
جی سر.
وہ تو بعد کی ڈیٹس ہیں نا.
سر ڈیورنگ ٹرائل ایک ریٹائر ہوئے, ایک بیمار ہوئے. It started with a 9-member bench and
of the appeal.
During the proceedings.
نہیں دیکھیے, now comes maybe, I'm just raising a question. Is this impropriety once a case starts with a particular bench, پھر اس کی reconstitution ہوئی یا نہیں ہوئی? Because I don't know. So do you have the answer to this or not?
جی اس میں ہے سر. اس میں اس طرح وہ جسٹس قیصر خان ریٹائرڈ.
He can retire, but he can be substituted by another 9-member bench.
That is what
but you said it fell short of 9 members. It went down to 7.
7. One fell ill.
Why would they not replace by others? Because from my perspective, an ad hoc judge, a normal judge is equal to us. Agar if we start making this distinction, then it's another can of worms. Let's leave that aside.
So ان کے ٹینیور ایگزیکیوشن کی فوراً بعد ان کو کنفرم
وہ ایک
جج.
الگ پوائنٹ ہے, ٹھیک ہے, but I'm just saying کہ how did 9 become 7?
In the
Either
recent,
you start with 7, fine, you can start with 3 even.
in the recent past, we started with 9 and ended up with 6. Was it an election matter?
Well, there is an explanation for that, but here
Election.
of judges at that time, 9.
Supreme Court की.
Yes.
Because I think we'll have to see the original file of the Supreme Court to see how were the benches reconstituted. Because this probably will not be mentioned in the judgment unless it is.
اس میں judgment میں یہ تو
Because
لکھا ہے.
like for instance, how many we are today? 9. Right?
Yes.
I don't want the case to be dragged on, but one of us will be retiring soon. So does it become an 8-member bench, or should we substitute him with another 9-member? Ordinarily, one keeps the same strength of the
Mr.
bench.
Mansoor, could you tell us about this?
The total strength of the Supreme Court was 9.
Yes.
One judge who retired, new appointment was not made, the other judge fell ill, so the remaining 7 then.
نہیں, اس زمانے میں کیا total sanction strength تھی 9 کی.
Not a total. ایک بیمار ہو گئے, ایک ریٹائر ہو گئے, جو باقی ریمائنڈر.
اس میں 2 طریقے ہو سکتے ہیں نا, یا تو
ان میں ایڈ ہاک ججز بھی تھے.
جی سر ایڈاک تھے. نسیم حسن شاہ صاحب ایڈاک جج.
وہ کیسے ہو سکتے تھے جب اسٹرینتھ اوریجنل اسٹرینتھ کمپلیٹ
پوری نہیں تھی.
فل اپ کر کے پھر آپ ایڈ ہاک اپوائنٹ کرتے ہیں نا.
ہو رہے تھے اس وقت, وہ اپوائنٹ ہو رہے تھے, مارشل لاء لگا ہوا تھا.
دیکھیے یہ اصلی بات آ گئی نا. اگر تو جیسے what the learned attorney general has pointed out, if ad hoc judges can only be appointed, the constitution I don't think has undergone a change in this, that once the Supreme Court is full, then you add on. If the Supreme Court had 2 vacancies, then ad hoc could not have heard the matter.
کہ بعد میں امینڈمنٹ تو نہیں ہوئی آئین میں یہ کہ پہلے آپ اس
تو original it is unamended.
73 کا دکھائیں اوریجنل لائن جو ہے گلابی والا.
ہوگا اس وقت مارشل لاء انڈر سسپینشن, کانسٹیٹیوشن انڈر سسپینشن تھا. مارشل لاء میں
Let's not use this terminology. Let's not use this terminology. We'll hear the matter. Let's not use this
So
terminology.
there are 2 choices. You could either replace a judge and have the same strength of the bench, or you could have a smaller bench. That's exactly what happened recently in a 9-member bench that ended up with 6 or 5, whatever, 5.
My Lord, seek your indulgence on this very issue. My Lord, when Justice Wahiduddin took sick.
No, I'm asking a different question.
No, my Lord, I'm coming to that.
Okay.
Your Lordship's essential query was that how did the 7-member bench continue to hear the matter when originally there were 9? When Justice Wahiduddin took sick, this matter was taken up in court, and in PLD 1979, Supreme Court 38, in that judgment, the court itself said that we started off with 9, but he has fallen sick, and therefore the 7-member bench will continue to hear the matter.
Okay.
So that is.
Then how did the ad hoc judges come in? Were appointed. The next question is the Constitution.
My Lord, there was one ad hoc judge who was there in the original 9-member bench, who subsequently retired.
نسیم حسن شاہ صاحب تھی.
Who was the ad hoc judge?
That was
Dr. Naseem Hussain Shah continued. Justice Karam-Ilahi Chauhan was acting.
And I'm really confused.
Kaisar Khan was an ad hoc judge, my Lord, and then he reached the age of superannuation.
I think there's a missing link still. I really want to know, was the sanction strength of the Supreme Court at that time 9?
Yeah, 9, my lord.
Okay. Now the question is, when the strength falls below 9, how can an ad hoc judge be appointed till first the whatever number of vacancies are filled to bring the number up to 9, and then you appoint ad hoc? That's the present position in the Constitution. Was it different then?
No,
Let's look at the Constitution then.
it wasn't different at that time.
182.
कौन सी Constitution?
रोजा दें उनको भी किताब.
70.
Now, I think the position was slightly different then.
देखें इसमें. Every time not possible, I want to forum judges.
We are going more into the merits of the case. What were the questions formulated, legal question, for the disposal of the reference, presidential
I'm not
reference?
discussing merit at all. I'm only discussing the complexion of the court and what was influencing, or if there was any bias, irrespective of merits of the case. I would not go into the merits of the case at all.
वो उसकी बेसिस पे आप उसको विशिएट तो नहीं कर सकते.
Okay, maybe we come to this later after we've consulted it. Ji, please continue.
The point I was trying to make was that the tenure of majority judgments was not secured.
Who are they? Can you name them now?
Mr. Justice Karam Ilahi Chauhan, he was acting judge between 27th April 1978 till 30th.
कहाँ से आप ले रहे हैं? कहीं लिखा है?
ये मैं सुप्रीम कोर्ट की वेबसाइट से ये
No, have you written it in your book?
D clause E में लिखा है सर.
E में. Okay, fine, then you don't have to. Fine, we can read it from there. ठीक है, got this point. Next point.
So the next point is about the element of bias.
Ji.
Now, if I may just refer to the paragraphs in which the issue of bias was addressed in the Supreme Court's judgment.
Ji.
It is in paragraphs 841 to 915. And that even included the conduct of setting up a cage in court in which Mr. Zulfikar Ali Bhutto was made to sit in a cage. And Supreme Court found nothing wrong with it.
ये कहाँ है?
So ये judgment के अंदर इन्हीं paragraphs में ये सारा
Lahore High Court.
Lahore High Court which is.
Was that factually so?
It was factually so. It was taken as a ground in a,
No. Did he sit in? Was
he was made to sit. और justify ये किया गया कि so that
it happened, or just we are talking language here?
no, they set up, they brought in a cage-like box in which he was made to sit, and justification was given that he is to be protected.
By
Protected from and by whom? And then they said because this was the first time a trial was conducted by High Court and there was no dock, so that's why we have set up this cage.
किधर है जिक्र?
So ये
Is there a
judgment में
judgment
Supreme
में
Court.
दिखाएंगे आप हमें judgment में ये केज का जिक्र कहाँ?
तो ये इनफैक्ट मैंने ये जो मार्क किए हैं पैराग्राफ्स 841 onwards, each para is
नहीं, हमें हाई कोर्ट का पहले दिखाएं. کہیں لکھا ہے ہائی کورٹ کے ججمنٹ میں کیس
سپریم کورٹ نے انڈیکس بنایا اس میں یہ لکھا ہے.
چلیں بتائیں.
یہ سر پیج 53 سے شروع ہوتا ہے ججمنٹ.
یہ کیج والی بات ذرا بتائیں.
جی سر اس میں سی ایم اے میں تھی.
یہ نیا فلسفہ کے پروٹیکشن کے لیے کیج کی ضرورت ہوتی ہے.
ہیوملیٹ کرنا, وی آل نو واٹ واز.
نہیں ذرا وہ دیکھیں تو پہلے, بیکاز اٹس سچ اے لانگ ججمنٹ. اٹس
تو یہ ان کی انڈیکس انہوں نے سپریم کورٹ نے شروع کی تھی پیج 54 سے, اور
اس میں تو نہیں بتائیں گے نا, آپ بس بتا دیں ہمیں کس جگہ ہم پڑھیں.
میں I'm just trying to identify کیونکہ each ground was so unique.
I incidentally, Iran, I saw that it was iron bar.
کس طرف تھا, جیسے یہ کورٹ روم ہے کدھر رکھا ہوا تھا, ایسے
جیسے وٹنس باکس کا سائز ہوتا ہے اس ٹائپ کی.
اچھا اوکے ٹھیک, اونچا کر دیا ٹھیک.
But the other going up to that are like prisons, which I've seen also many times. They were like prisons.
I'll point it out.
انہیں آگے بتا دیں, you can always tell us later.
874. Thank you. Paragraph 874. 874. 874 at page 370.
کون سا پیج بتایا خالی صاحب؟
370.
370 page, paragraph 874.
جی پڑھ دیں.
In the courtroom in the High Court in which this trial was held, there was no dock, and it was therefore installed before the commencement of the trial. According to the appellant, this dock was specially devised to cage, humiliate, and devalue him in public eye. This may be an unfortunate impression formed by him in the circumstances, but otherwise the necessity for segregating the accused was genuine and apparent from the fact that very great interest had been shown by the public in this case. It is therefore difficult to doubt the bona fides of the court in installing the dock in question. Similarly, there appears to be some room for misunderstanding concerning the remarks about the benches against which the appellant was aggrieved. The allegation that as a result of the seating arrangement in the dock, the appellant and his learned counsel were handicapped in communicating with each other in the court for the purpose of this case is not borne on from the record. It does not appear that any complaint to that effect was at any time brought to the notice of the court, or any application was at all moved in court to draw its attention towards any such difficulty experienced by the appellant in the course of the trial. Before us, neither the other accused nor any of their learned counsel supported the appellant in this complaint, nor did they ever make any such grievance in the court. In the course of the trial on 1/1/77, this is a different ground that the Lahore High Court Chief Justice had become the election commissioner, and he had made personal remarks about the misconduct of the accused in elections.
All accused were sitting in one cage, or only Mr. Bhutto?
Perhaps only Mr. Zulfikar Ali Bhutto.
What about the other accused persons? They were sitting where?
It doesn't. They didn't require security, maybe.
Because ordinarily the High Court does not conduct trials. Now, one thing which I wanted to know, how many trials has the High Court conducted in Pakistan's history? Trials. So this was a trial conducted by the High Court. ایک تو یہ ایسپیکٹ تھا, مے بی ہمیں وہ کرمنل لا ایکسپرٹس ہمیں یہ بتائیں گے. So that may be a reason, because ordinarily in a trial court the accused sits somewhat separately. I don't know. That could be the reason.
My lord, but this, along with the manner in which the appellant, in that case, Mr. Zulfikar Ali Bhutto, was treated, there is an exchange between the then Chief Justice of Lahore High Court and Mr. Zulfikar Ali Bhutto. It's all again narrated in these paragraphs. There was so much vitriol, there was so much heated exchange between them personally, and the reason, rightly or wrongly, was that perhaps the Chief Justice of Lahore High Court was bypassed.
हमारे लिए एक मुश्किल हो गई, which could have been easier way to solve it. There was apparent bias in the Lahore High Court, but all those grounds of apparent bias were addressed by the Supreme Court. Correctly or wrongly, we won't go into that. So to that extent, if we substitute our finding, would be we want to stay clear of the review jurisdiction aspect of it. So ye bhi agar ek cheez miss kar dein Supreme Court, that this point was not considered, would be slightly different from a point considered and repelled.
Well, your lordship will have to look back at the context. Ordinarily,
वो एक अलग बात है.
so without that, the case could not be appreciated. Now, today we live in a very different society. At that time, thousands of political prisoners were in prisons. People were lashed, people were hanged, and there was absolute ruthless martial law in the country. Now, if the Olympian detachment of today's society, unless we transpose ourselves, some of us who were around at that time, we have witnessed it. Many of the people of younger age, they cannot envisage. Journalists were lashed, and people were imprisoned for years and years for raising a slogan through military court trials. My parents were convicted. The then Lieutenant Commander was a gentleman. He told my father that I've been directed to sentence you for 1 year and your wife for 2 years because she is more abusive of General Ziaul Haq. And this was the trial. So I am a first-hand witness also. But again, I want to stay out of that. I am an amicus. But unless we actually envisage what sort of society we were living in, there was not only bias in the High Court, there was also bias in the Supreme Court. The tenure of the Chief Justice was curtailed. Your lordships have framed a particular question about that. I'm sure the Learned Attorney General plays the record, but there was manipulation.
What about tenure? You're saying Chief Justice tenure was curtailed?
So, Justice Anwarul Haq had become Chief Justice because of the manipulation. And this was specifically the order passed by this court. Honorable Mr. Justice Iftikhar Mahmood Chaudhary, as the lordship then was, he passed the order that AG will place the record of the appointment of Justice Yaqub Ali and his removal. So this is the context which needs to be...
Do you know anything about it? Please tell us, we'll make a note of it.
So, in the context of first, when the martial law was challenged...
Justice Yaqub, you said his tenure was curtailed.
Ji, sir. I'll place exact details, but there is a direction to the...
No, we'll ask him, but if you know something, please tell us, or we move ahead.
So when he was not agreeing...
if you have any facts...
So, I have not...
ठीक है, आगे फिर बढ़ते हैं. Let's proceed.
My request would be that perhaps we need to envisage the context. Otherwise, this case would not make sense. And ordinarily, your lordship's concern is very valid that we don't want floodgates, that everybody who faced a trial during a particular period comes back. But here is a case where there is a targeted person.
This is a unique case.
Indeed, my
and
lord.
there's no other case
There
which
is no other case
can be compared with
parallel
it.
yet.
Anything further?
Then, my lords, I have taken some... I have referred to certain judgments of Pakistan Supreme Court and from England and other jurisdictions where particularly there is one case where the judge had intervened too much and then the entire trial was found to be unsafe by the United Kingdom Supreme Court.
But that must be in the judicial hierarchy, right? We're talking about a totally different jurisdiction.
जी बिल्कुल ऐसा ही है.
वो इसलिए उस कॉन्टेक्स्ट में देखना जरूरी है. आप हमें वो ग्राउंड्स तो बता दें ना, मटेरियल तो बता दें. जिस मटीरियल से आप ये सारा शो कर रहे हैं, that's important for us to understand. It's a totally different jurisdiction.
So, grounds and material was, first of all, what is recorded in the judgment of Supreme Court itself. That perhaps is more than sufficient to demonstrate that this was a unique case where there was an individual who was targeted through the executive pressure on the judges. And
है ना material, pressure वाला.
so there is contemporary material available. There is no first-hand evidence.
जो भी आपके पास है material बताएं, judge under pressure.
So there was a book published. The author was Victoria Schofield.
बुक्स की बात नहीं है. देखिए, एक जजमेंट, ये वेल लेबल्ड जजमेंट है, बड़ी लेबल करके लिखी गई है. अब उसमें 22 के पॉइंट को भी उन्होंने देख लिया अच्छे तरीके से. अब विदाउट सेटिंग साइड द सेट जजमेंट हम कैसे दोबारा 22 को ले सकते हैं? पहली बात आपने कहा जी मिसकैरेज ऑफ जस्टिस को हम देख सकते हैं और ये कर सकते हैं. उसके लिए हमें लाजम होगा कि उस जजमेंट को हम सेटिसाइड करें. वो हम कर नहीं सकते क्योंकि रिव्यू भी आपने एग्जॉस्ट कर लिया है. अगर वो सेटिसाइड कर दें तो फिर उसके बाद जो हाई कोर्ट की जजमेंट है वो इनफील्ड रहेगी. तो आज का मतलब ये है कि आप ये कहना चाहते हैं कि हम इस रेफरेंस में बैठ के 3 जजमेंट्स, रिव्यू, अपील और ट्रायल कोर्ट की जजमेंट को पहले सेटिसाइड करें और उसके बाद आए. ये कैसे हो सकता है? जबकि 22 को सुप्रीम कोर्ट ने, आप खुद बता रहे हैं, पता नहीं कितने पैरे लिख दिए, उसको डील कर ली है. और देखिए आप जजमेंट को जब देखते हैं तो उन्होंने ईच एंड एवरी पॉइंट को उन्होंने इसको मीट किया है विद द प्रीवियस रेफरेंसेस. वेल लेबर्ड जजमेंट है ये. इसको ये नहीं कहा जा सकता लेकिन अदरवाइज वेल लेबर्ड जजमेंट है. तो ऐसी सूरत में विदाउट सेटिंग साइड द जजमेंट हम कैसे इसको आगे लेके जा सकते हैं और क्या कर सकते हैं? इसका जवाब दीजिए.
मेरी सबमिशन ये नहीं है that the court should set aside the judgment. That is not possible because that requires statutory provision. What this court can do is to look at the judgment, read the judgment of the Supreme Court, and if your lordships are convinced that the reasons given not on the merits of the case.
इसमें बात तो फिर वही आ गई ना कि we can only render the opinion. We cannot wipe out 3 judgments, Lahore High Court, Supreme Court, and the review jurisdiction. So what is the effect of our opinion? What we will hold?
The effect of opinion would be the conclusion that the trial was unsafe. There was miscarriage of justice in that case, and that is where it stops.
And judgment will remain intact.
If they want to undermine the basis of judgment, many other countries, including United Kingdom, have given all
that
this.
statutory legislation undoubtedly, I mean, a strong word, but the judgment is belabored. As we note it, I mean, it's such a criminal case, and I mean, I don't know why we went into such great fine details of it. So just the fact that an opinion is rendered, naturally you can't undo the judgment, but an opinion in itself may be vindication enough. I don't know.
Perhaps that's what is sought through
but
this.
that
We can start with it. I mean, that's why I keep going earlier in time. Nobody wants to go there. लेकिन यही बात हमारे माशरे में अजीब सी है. जब हम इस्लाम की बात करते हैं तो कोई करना ही नहीं चाहता है. हम कह रहे हैं इस्लाम जूरिस्प्रूडेंस में कुछ बताएं तो आप चले जाते हैं अमेरिका और विलायत वगैरह. भाई हमारे आइन में कहीं नहीं लिखा है कि अमेरिका के कानून को फॉलो करेंगे, विलायत के प्रेसिडेंट को फॉलो करेंगे या इंडिया के प्रेसिडेंट्स को फॉलो करेंगे. मगर जहां तक हम बात करते हैं कुरान शरीफ की, या आप कोई भी नहीं आता है हमारी ताउन मदद करने के लिए. भाई अगर एक अदालत ने गलती की है, इस्लाम क्या फरमाता है इसके मुतालिक? कुछ कहता है या खामोश? मुझे नहीं पता. We went into such great fine details of it. So just the fact that an opinion is rendered, naturally you can't undo the judgment, but an opinion in itself may be vindication enough. I don't know.
Perhaps that's what is sought through
but
this.
that
We can start with it. I mean, that's why I keep going earlier in time. Nobody wants to go there. लेकिन यही बात हमारे माशरे में अजीब सी है. जब हम इस्लाम की बात करते हैं तो कोई करना ही नहीं चाहता है. हम कह रहे हैं इस्लाम जूरिस्प्रूडेंस में कुछ बताएं तो आप चले जाते हैं अमेरिका और विलायत वगैरह. भाई हमारे आइन में कहीं नहीं लिखा है कि अमेरिका के कानून को फॉलो करेंगे, विलायत के प्रेसिडेंट को फॉलो करेंगे या इंडिया के प्रेसिडेंट्स को फॉलो करेंगे। मगर जहाँ तक हम बात करते हैं कुरान शरीफ की, या आप कोई भी नहीं आता है हमारी ताउन मदद करने के लिए। भाई अगर एक अदालत ने गलती की है, इस्लाम क्या फरमाता है इसके मुतालिक? कुछ कहता है खामोश? मुझे नहीं पता, मगर मुआवनत तो मैं समझ रहा था कि मिलेगी, मगर मुआवनत नहीं मिलती है। अब यही देखिए ना, अब जब बार बार ये सवाल आपसे उठा रहे हैं, अब फिर आप अगर आपको ट्रायल्स देखना है, हिस्टोरिकली ट्रायल्स, हजरत ईसा अलैहिस्सलाम की जो ट्रायल हुई थी, सनहीड्रिन ने जो की थी, तो फिर आप वहां भी जा सकते हैं उस पर एक वक्त में। फिर आप सोक्रेटिस की ट्रायल भी बात कर सकते हैं। तो वो एक जजमेंट ऑफ हिस्ट्री या ओपिनियन भी एक चीज हो सकती है। ऑफ कोर्स उनको खत्म तो नहीं किया जा सकता है कि सोक्रेटिस के साथ क्या हुआ, मगर एक अगर वो कोर्ट्स अब रही नहीं, मगर जो कोर्ट रही है अगर कुछ दुरुस्तगी की तरफ जाना चाहती है तो तरीक़ेकार क्या होगा, ये बात है। अब सबसे जो उसका नतीजा तो नहीं चेंज कर सकते। अब हमने जैसे कि पहले मार्शल लॉ पे बात हुई, फिर जजमेंट आ गया कि गलत है, वो भी तो जजमेंट ही थे ना सुप्रीम कोर्ट के। तो एक तरह से जो भी आप कहें उसको रिव्यू किया या क्या किया, प्रेसिडेंशियल रेफरेंस आया या नहीं आया, मगर एक और जजमेंट में उन्होंने एक और राय ले ली। तो अब हमें सिम्त तो ठीक कर लेना।
आप प्रोस्पेक्टिवली हमेशा डेविएट
कैसे करेंगे ये बता।
आप वो तो कोर्ट की इनहेरेंट जुरिस्डिक्शन है। इफ यू लॉर्डशिप वुड रिकॉल लिवरसिज वर्सेस एंडरसन, a very infamous judgment of Britain. Subsequently, the House of Lords observed that their lordships were excusably wrong in Liversidge versus Anderson. So prospectively,
उनका मसला और हमारा मसला बहुत फर्क है। उनका तो एक तो आइन लिखा हुआ नहीं है, ठीक है, वो उन्होंने कर दिया, कैसे किया मुझे नहीं पता कैसे किया, ठीक है। उन्होंने कहा जी हम हर कुछ कर सकते हैं। अगर आप हमें इतने ज्यादा इख्तियार दे दें, कल आप ही हमारे सामने खड़े होंगे और कहेंगे कि नहीं जी आप पाबंद हैं आइन पे और आप हर कुछ नहीं कर सकते हैं, और मेरे ख्याल में सही कहेंगे। तो वो एग्जांपल्स मुझे कुछ समझ नहीं आ रहा है, मैं उनको क्यों फॉलो करूं उन एग्जांपल्स को, मगर हमें इस्लामी तारीख से कुछ बताया नहीं जा रहा है।
एक सेकंड, एक चीज स्पीकिंग फॉर माई सेल्फ, बड़ा आसान मैं आपके लिए करता हूँ। As I see it, हम 186 में जब किसी चीज को जजमेंट को देखेंगे तो हम कहेंगे उस जजमेंट पास होने के बाद हमारे पास कोई मटेरियल ऐसा आ गया है जिससे सिर्फ ये जाहिर होता है कि उस वक्त जजेस इंडिपेंडेंटली फैसला नहीं कर सकते, कोई मेरिट्स में नहीं जा सकते। आप सिर्फ ये कहेंगे कि जजेस वर नॉट ऑपरेटिंग एज जजेस बिकॉज दे वर आइदर बीइंग डिक्टेटेड और समथिंग। उसका मटेरियल दिखा दें, इतना सा केस है सारा।
सर पैराग्राफ 841
उसमें नहीं आते, बस सारी बातें गोल।
मगर आप माय लॉर्ड ने जैसे ऑब्जर्व किया सरदार साहब ने कि अगर आप पैराग्राफ पे रेफर करें कि इसका मतलब है फिर हम रिव्यू में बैठ गए,
उसमें तो
ये देखिए
रीजनिंग आप देखेंगे,
गलत किया सही किया कर दिया
सर, वो रीजनिंग आप देखेंगे। एक रीजनिंग ये भी थी दैट फोर्स,
मैं आपसे एग्री भी करूं तो फिर मैं कौन सा जुरिडिक्शन हूं।
और रीजनिंग को छोड़ दें, अब आपसे पूछ रहे हैं कि हमें पता चला ये केस डिसाइड हो गया, बाद में मटेरियल जैसे हुए, लोग बोले, कोई मटेरियल आया कि हम इंडिपेंडेंट नहीं थे। I'm all with you. I just want to look at that material which shows these judges were not independently deciding the matter. Then miscarriage हो गया। वो दिखाइए ना मटेरियल, और तो कोई एंट्री का पॉइंट ही कोई नहीं है इस केस में।
मैं एक आपको जजमेंट अभी रिसेंटली ऑफ द सुप्रीम कोर्ट इटसेल्फ,
नहीं आप मटेरियल, एक्चुअल मटेरियल बताइए ना। ये कहना कि मार्शल लॉ था वो काफी नहीं है ना।
सर मेरी रिक्वेस्ट ये है कि when unless we look at para 841 में how bias was justified, we would not be able to come
हम आपकी बात समझ
see the reasoning.
अग्री भी करते हैं, मगर जरा आप हमारी दुश्वारी भी जरा समझे ना। हम ये तो नहीं कह रहे हैं कि हम आपसे एग्री नहीं करते हैं, हम कुछ और बात कर रहे हैं आपसे। जरा उसका तरीके का मतलब अमाइकस हैं, सॉरी आप इतना ऐसे डालना नहीं चाह रहे, मगर जरा दूसरी नजर से देखिए।
या तो ये भी हो सकता है, देखें इस तरह हो सकता है कि आप कहें कि जैसे एक जजमेंट है, ये जजमेंट पब्लिक प्रॉपर्टी बन चुकी है, प्रेसिडेंट हमसे पूछ रहे हैं कि आप बताएं जजमेंट के बारे में आपकी क्या राय है। हम कह सकते हैं कि जजमेंट सही है या गलत है, लेकिन इसको हम चेंज नहीं कर सकते।
एग्जैक्टली यही प्रेसिडेंट ने आपसे पूछा है। प्रेसिडेंट हैज नॉट सेड दैट प्लीज चेंज द outcome of the case. What the President has asked this court is whether there was any miscarriage of justice, taking the facts as it is.
तो वो कैसे होल्ड करेंगे? How we can report our opinion unless we go through the entire evidence?
Sir, आप judgment
Unless we see whether there was any miscarriage of justice or not, and there was any bias.
और ये
It's
appeal
mean
के
that
ground
we have
होती
to
है।
go through the entire judgment
Sir,
again.
आप prospective overruling करते हैं तो वो अपील तो नहीं होती.
नहीं तो कल को फिर जितनी जजमेंट्स में हमने दी हैं, कोई हर दफा प्रेसिडेंट कह दे इस केस को भी देख लें, फिर हम सारा केस सुने
तो
दोबारा.
हर केस में आप रिजेक्ट भी करेंगे अगर ऐसा होगा.
नहीं, ये तो ये जुरिस्डिक्शन का
मगर
स्कोप नहीं है ना.
आप देखिए हमें एकदम से सवाल आप पे आ गया है. आप बेशक सोच लीजिए, हम आगे बढ़ सकते हैं. अगर आप मजीद कोई बात कहना चाहेंगे हम बाद में भी आपको सुन सकते हैं. अगर आप कुछ फाइल करना चाहें इस पॉइंट पे जरा ज्यादा फोकस आ जाए तो आप आगे बढ़े.
मैं जी एक आगे पॉइंट कर दूं. एक recent judgment I have referred to curative review. Now in Pakistan it had an odious background, but as a matter of jurisprudence it's a very sound principle. Usme I take the view that it's not available to state or authorities. It is only available to the aggrieved individuals or parties. Recent judgment in Supreme Court in Islamabad High Court case, it has been rejected, but perhaps the underlying reasons may provide some guidance.
नहीं मगर देखिए ना, अब बिल्कुल आपने बुनियादी खराब कर दिया केस का. केस की बुनियाद रखी गई है प्रेसिडेंशियल रेफरेंस पे. इन्होंने फाइल ही नहीं की क्यूरेट, हम उसको बैठ के तबसरा करने लगे. तो उसी बुनियाद पे रहते हैं, उसी से चले ना. ये नए पॉइंट आप खड़े हो गए.
ठीक है, we leave it for
Cannot convert the reference into curative writ.
वो
Not our right
I
under
appreciate
Constitution.
इसी पे रहें.
because it's 186 we restrict ourselves to Article 186. So there is a recent judgment of this court and if I may point out, a ground, Supreme Court has now taken this ground that trial should be open or proceedings should be open and transparent. Now, as I pointed out, there was part in camera trial.
कोर्ट में ओपन नहीं थी.
Sir, एक stage पे for a prolonged duration, the trial was in camera.
ये फैक्ट प्रूफ दिखाइए इस बात का.
So इसका ये page 171 है सुप्रीम कोर्ट की जजमेंट में, पैराग्राफ 340 onwards.
171.
Para 340. And if I may refer to para 345. Sir.
जी 171 पास कर गया. जी
जी सर.
साहब इसमें एक और सवाल का जवाब दे दीजिएगा कि जो बात हो रही है, the other brothers have also asked this question, how this case was directly tried by the High Court. Under section 265B CRPC there is a provision that the High Court can also try the cases like session court. But how it was transferred, whether there was any judicial order, there was any notification of government that this should be tried by the High Court and not by the session court.
An application was filed, perhaps by Mr. Kusuri, I may be corrected, and without notice to the accused, the case was transferred.
I think one of the amicus would attending to criminal trial will be attending to this point.
But for direct transfer ho gaya tha without notice to the accused.
Okay.
The para 341, 340, 45 agar hum pad lete hain sir. In the detailed order dated 9/178 passed on the transfer application, it is mentioned that it was decided to be taken up in chambers, and since not only it is the usual practice of the court to hear motion cases in chamber, but also the intention of the accused in repeating previous petitions based on allegations of bias appeared only to give publicity to the baseless allegations of a scandalous character and thus undermine the confidence of the public in the courts of the country. On appearing before the bench, the appellant expressed his surprise and made a request for the petition to be heard in open court. This request, according to the learned trial bench, confirmed their views that the object of the accused petitioner was clearly to give publicity to the highly scandalous scurrilous and baseless allegations in the petition and the arguments that might be addressed in that connection. Therefore, the bench did not agree to the request of the appellant. In these circumstances, the learned trial bench heard the arguments in chambers on the transfer application in the presence of the appellant and of his two learned counsel. It appears that in the course of arguments by Mr. Dost Mohammad Awan, his learned senior counsel, the appellant intervened to make certain submissions of his own, despite the fact that it was brought to his notice that he was interfering with the proceedings. After the conclusion of the arguments by his learned counsel, the petitioner was also allowed an opportunity to supplement the arguments on facts as a special case. However, according to the impugned order, the appellant started a political speech in the court. He was asked several times to confine himself to the petition and refrain from making a political speech. Ultimately, he took his seat, saying that if he was not allowed to say what he liked to say, he would not make his submissions. I shall separately deal with the merits of the allegation contained in the transfer application and the order passed thereon at the suitable place in his judgment, But for the present, suffice it to mention here that the appellant had taken exception against the hearing of his application in chambers on wholly untenable grounds and had therefore on the same day voluntarily chosen to dissociate himself from the proceedings at his trial in open. Then there is discussion of what is open trial mean, what open trial means. The Chambers dictionary is relied upon, and then the application was dismissed. And on the sole ground that he may make scurrilous or scandalous attacks on the court. This again vitiates the proceedings, and it is completely incompatible with the jurisprudence of this honorable court, particularly in recent years, that open and...
Any other point?
So finally, I have enumerated the statutory provisions in different countries.
वो तो ठीक है, हमारी यहाँ है नहीं तो हम क्या करें?
जी सर,
वो आपकी बात दुरुस्त है, पार्लियामेंट कल बनाना चाहे कानून बनाए, हम पार्लियामेंट को कोई हुक्म, मैं तो नहीं देता हूँ हुक्म,
वो तो recommendation because president is part of parliament.
जो मर्जी करे.
And then I have enumerated the cases which deal with bias, and in each one of those cases, it was sufficient that even if one member, particularly, जी sir.
ठीक, anything else? अगर मजीद आपको कोई कहना हो या कुछ फाइल करना आप कर दीजिएगा.
सिर्फ मैं
जरा आपको इसलिए जरा जल्दी कर रहे हैं क्योंकि और भी काफी लोग.
जी जी, I understand. I'm very grateful, sir.
No disrespect intended.
No, sir, I'm very grateful. सिर्फ मैं सिर्फ एक recently अगर, if I may read one paragraph from the recent judgment passed by this honorable court, if I may lay my hands to that. One of the learned sitting members of the Supreme Court has passed an order and made observation about the trial in Zulfikar Ali Bhutto case itself. So it's in the...
Why are you referring to that?
So the present honorable judge of the Supreme Court observed that the conviction in that case was unsafe. Was it's one of the rarest of cases.
ठीक है, उसको छोड़ें. No, नहीं, वो तो एक, let's leave that.
But I just wanted to indicate.
Judgment हम पढ़ लेंगे.
Is that by a bench or what?
Reported judgment है.
It's a reported judgment.
Just give us a citation.
जी sir. It's authored by Mr. Justice Athar Minallah, and it's Islamabad High Court Bar Association case. I'll give the exact citation. I've somewhere taken it out.
Yeah, reported है. CLD 2023 Supreme Court 720. I think this is the one you're referring to.
Yes, my lord.
Islamabad High Court versus Election Commission.
Yes, election, exactly.
We'll go through it.
Mr. Justice Athar Minallah had made.
So then you've got a declaration.
So,
What do you want more?
your lordships are invited to join the declaration.
नहीं, वैसे कह रहे हैं कि सुप्रीम कोर्ट ने कह दिया.
तो उतना ही शायद president is expecting that your lordships would share that opinion. I'm very grateful, sir.
Thank you, Mr. Khalid Javed Khan. Who's coming next? Is Mr. Salahuddin Ahmed coming next?
23.
Salahuddin Sahab, aap aa rahe hain pehle? Next? Ji. Have you also filed something?
Yes, sir. I filed a note, and then there are two books of the materials.
हाँ? तो बड़ी मेहनत की आपने.
कोशिश की है थोड़ी.
ये वो repetition तो नहीं है जो मखदूम साहब ने फाइल किया?
I haven't had the opportunity of looking at Makhdoom Saab's. There are two booklets. One is on advisory jurisdiction, and the other is on bias and miscarriage.
Bias and miscarriage. अच्छा जी, ठीक है. And you filed CMA number?
Sir, this filed today. It's
1359.
1359.
2024.
हमें भी दे दीजिए अगर है.
1359 2024. Do you want us to open the CMA or you want
the CMA, sir.
जी.
आपके साथ देखिए मुस्तफी ने जो
नहीं, दोनों मेरे पास दो हैं. 1359.
Sir, in essence, what this reference asks, if all those 5 questions are distilled, is whether the conviction and execution of Zulfikar Ali Bhutto amounted to miscarriage of justice. But can this court answer this question under 186? If so, to what extent? And are there any other avenues available to address miscarriage of justice? And even if this court reaches the opinion that it was a miscarriage of justice, what is the legal effect and consequence of that opinion? Now, first of all, sir, there are a couple of principles relating to advisory jurisdiction, which I may briefly advert to. Number one is that only questions of law can be gone into. India or Canada may, or England may be. I've given the relevant statutes and the constitutional provisions in the note. There you can go into questions of fact and law. But in Pakistan, obviously, we're confined to questions of law. The impact of that is, sir, that as far as some of the factual issues are concerned, whether a judge was biased in fact, factual bias agar tha ya nahi tha, whether due to pressure from martial law authorities or due to personal animosity, being superseded, etc., those questions perhaps cannot be gone into because they are factual questions. Number two, that the president is the sole judge of the public importance of the question and the desirability of referring it to the Supreme Court. Number three, that because of the mandatory language in 186, the court cannot refuse to consider the reference. It has to consider it. It may nonetheless report its opinion that one or the other question is not capable of answer because it's not a question of law, it is a question of politics, or it is too vague or general, or it has already been addressed in earlier decisions. Even that is a ground on which not to give an answer. The fourth is, sir, that this court under 186 does not have suo motu powers, and it does not have the plenary power to do justice as in Article 187. It is only confined to answering the president's questions, albeit with the caveat that if the president's questions are vague or imprecise, this court has the power to narrow down and refine those questions and isolate the precise legal issue that requires answering. That power is available.
Which has been exercised
Jeez,
already.
Your lordships are doing it as we speak.
No, before us, the bench had reformulated the questions also.
Jeez. Now, finally, sir, these are the 2 points which I think are very important for this case. The fifth is that this court cannot set aside earlier decisions made in adjudicatory jurisdiction, whether in point of fact or in point of law. At least as far as the decision inter partes is concerned, that cannot be touched. It is res judicata. Uspe, sir, there are a number of judgments which I'll just come to, but the sixth point is one in which there is a divergence in the case law. Even if the judgment itself is res judicata inter partes, obviously, as your lordships often do in subsequent cases, your lordships modify a principle of law laid down in an earlier judgment, the concept of stare decisis as opposed to res judicata. Your lordships frequently amend, modify, correct principles of law that have been laid down in earlier judgments. The question is whether your lordships can do so under Article 186. Now, in India, there were two views taken. The Indian Supreme Court, in the case of, in the reference relating to Qazi, there the Supreme Court said that because we are in the advisory jurisdiction, we can neither set aside an earlier judgment, we cannot affect its finality inter partes, nor can we deviate from the principles that have already been laid down in the adjudicatory jurisdiction.
Which judgment was this?
Sir, this was the judgment of Qazi 2 reference. It is reported at AIR 19.
Which is it here?
Ji, sir, tab number 6.
Of volume 1?
Ji, sir.
What is the citation, AIR?
AIR 1992, Supreme Court 522. और उसमें सर relevant para जो है, I'll just take
second, Qazi. Can you repeat the citation?
AIR 1992, Supreme Court 522. And this is tab number 6 in the first booklet. और इसका सर जो relevant para है, वो 21 to 23 है.
Ji.
I'm sorry, I just...
Ji.
I'm sorry, sir, I'm just trying to isolate the power. Ji, sir, ये page 254 पे होगा, sir.
It starts at 522, you said.
नहीं, ये इनका हाथ में लिखा है.
अगर बुकलेट में सर page 254 देखेंगे.
जी.
And इसमें सर, this court by its decision, this court by its decision of April 26, 1991 has held, as pointed about above, that the central government had made a reference to the tribunal for consideration of claim of interim relief paid by state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request. Being a part of the reference, implicit in the said decision is the finding that subject of interim relief is a matter connected with or relevant to the water dispute within the meaning of section 5(1) of the Act. Hence, the central government could refer the matter of granting interim relief to the tribunal for...
Which page are you?
Sir, this is at 254 of the
handwritten
Fine. Booklet.
Yes.
Fine. Please carry on. Please.
Yes, sir. Although this court by the said decision has kept open the question with whether the tribunal has incidental, ancillary, inherent or implied power to grant the interim relief when no reference for grant of such relief is made to it, it has in terms concluded the second part of the question. We cannot therefore countenance a situation whereby question 3 or for that matter, question 1 and 2 may be so construed as to invite our opinion on the said decision of this court.
Basically, they said you can't do it.
You can't do it.
Yes, but then they changed their own view.
Yes, sir. They changed their view in the subsequent judgment which was referred to by Mr. Makhdoom Ali Khan. That was the 2G reference case.
2012.
जी सर. वहाँ उन्होंने ये कहा,
ये भी 5 मेंबर हैं, वो भी 5 मेंबर हैं.
जी सर.
तो I'm not very clear.
Yes, sir. Now, in the 2G reference, they said,
Why we again placing so much emphasis on these Indian judges?
sir, I'll just come back to the Pakistani jurisdiction, but my point is this. In the 2G reference, they said that inter parties we cannot change the decision, but principles of law we can redefine, modify, correct.
Change the ratio of the judge.
Change the ratio. Now, in Pakistan, sir, this has been followed, and I think your lordship was referring to that. That was in PLD 2013 Supreme Court 279. वो जो appointment of judges वाली reference थी, उसमें Qazi 2 was followed.
And just for myself, you see, what according to you is the question of law that you see in this case?
Lord, in this case, the question of law that I feel that has not been answered before is the question of bias that arose on account of the interview and the book of Justice Naseem Hassan Shah. That was a question that was never previously dealt with by the court.
So how do you frame the question of law?
My lord, the question is whether the judgment was vitiated by bias on account of the revelations made by
A judge later on.
Yes.
Fair enough.
If you give this opinion, what will be the impact of that judgment?
My lord, the effect of that judgment, if your lordship, there are two separate strands here, sir. If your lordship takes the view that was taken in Qazi 2 and in appointment of judges case by this court, that even principles of law cannot be changed, even then your lordships can give an opinion that there was subsequent bias that wasn't ever considered by the court, and we can give our opinion on that. What that opinion will do is it will not change the principles of law in Zulfikar Ali Bhutto, but it will nonetheless give some vindication.
We will ask the judges to be careful in future.
My lord, and this is why I said that the desirability of the reference, that is a question for the president.
Is this the only bias you are claiming?
My lord, all the other instances of bias, and I think there are numerous, which Khalid Javed Khan sahab bhi jinka tazkara kar rahe the, but the problem is that in one way or the other, even the bias of Justice Anwarul Haq, there was a specific application moved to the Supreme Court, which was rejected by the Supreme Court. That was also reported. So all those aspects of bias were covered. Some of the aspects of bias...
But you are forgetting another overall bias. Why not the manner you are attacking now, the bias in the system in its entirety, which the Supreme Court had not considered itself in that case? The fact that if we do not convict, the persecuted may become the prosecutor tomorrow, that the Supreme Court judgment doesn't say, and invoke Article 6, that we may lose our job. I mean, so what about those things which are part of history, but not articulated in the Supreme Court judgment at all, and not, which may have been alluded to, whether Justice Naseem Hassan Shah says it or not, these are facts of history. So what about that? Can that be not considered as a bias which the court did not consider, and it would not have considered it?
My lord, the difficulty that I have with that, and there are of course things which are historical fact, but the difficulty I have with that broad proposition is that it is difficult to decide then where to stop it. Which of the judgments that were rendered during that period should be retained? Which of those judgments should be assailed? Because although
may I solve your difficulty? There is only one case before us, presidential reference. Why are you worried about whether there'll be another presidential reference? We'll attend to it. So short answer could be that there's only one case before you.
My Lord, it does open floodgates of future.
That is the concern that I had. That is the concern that I had.
Now, sir, आपके paragraph 4 में page 5 पे in your paper book, you have already stated that the question of bias has been decided by the judgments of the court and it has become a res judicata.
Yes.
तो आपके हिसाब से तो आप bias को भी नहीं देख सकते. What is your opinion?
जो bias उस वक्त तक जुल्फिकार अली भुट्टो साहब के वकला ने जो उनके मालूमात में थी, जो उन्होंने प्लीड की, वो तो तमाम चीज खत्म हो चुकी है. मगर जो चीज बाद में इंकशाफ हुआ, that bias.
आपका फिर question of law ये बनता है कि question of law ये है कि there was a miscarriage of justice because subsequently we discovered through some material that the judge was not independent at that time. This is the only question.
Yes.
My next question would be कि एक तो उसको देख लेते हैं उस material को. Secondly, you're also saying that in this question of law we cannot inquire into the factual dispute.
Yes.
So this either this material ought to be just undisputed. And then we could rely on it. Because it's a question of law we need to answer. We can't get into inquiry. We cannot probe into matters. We can't look at facts. So, but the question is very simple. There's miscarriage of justice because of the subsequent material that came to surface and whether at all that affects the judgment.
Yes.
With the worry that you place about floodgates of litigation, one could also say that when judges retired, people will be running after them to write a particular book saying a particular thing so they can undo a particular judgment. You mean to say that is more important and we should ignore the other bias which is inherent in the whole system at that time, which is not important, and this particular book or this particular interview becomes more important? I have difficulty with that. I can accept the earlier proposition more than the latter one, and maybe some others have the other view. So I don't know.
Very difficult for a judge to write this eventually, that he was under pressure.
I was trying to think of any other example and I couldn't think of any other example where a judge has said
he doesn't even go that far as to say. He says I'm under pressure. I can always say I'm under pressure all the time, That's a general thing. But to say I decided this case wrongly, intentionally, it should have been the other result is a different thing.
That's right.
I mean, judges, every case, every murder case, every session judge would be under pressure. What should I do? I mean, I don't know.
So if we can get done with this material first, which we say that is the sole document which establishes miscarriage, talks about a generic pressure.
No, sir. There are at least 4 specific places where he talks about the
pressure keh rahe hain, magar wo ye to nahi keh rahe ki maine
नहीं सर, मैं उन पे आऊंगा. अगर एक चीज मैं उससे पहले
but proceed in your own way.
जी मैं अभी उस पे आता हूँ. I'll come to bias immediately. ये para 4 से ही. Now, sir, bias, as your lordship had observed on the last date of hearing, bias is sometimes an inappropriate term because bias implies a manifest partiality or favoring someone. Whereas जो case law में bias use किया गया है, उसमें the concept is any extraneous consideration to judicial adjudication. So that is, sir, I have pointed out a judgment of that is at tab 12 of the UK House of Lords, that's Davidson versus Scottish ministers. I won't read it, सारा मैंने उसमें include किया हुआ है, but any extraneous factor to the adjudication.
But in this particular case, in a reference coming out of 186, that extraneous consideration must be outside the case also.
Yes.
It cannot be something that was discussed, even though extraneous, but discussed in the judgment.
Yes. So it has to be extraneous to the earlier judgment and extraneous.
But in time and space, it must be extraneous.
Yes.
Mrs. Laudin, suppose हम ये मान लेते हैं कि yes, the man has given interview, और हम समझ लेते हैं कि वो ठीक कह रहा है. Again, what would be the impact of that interview upon the judgment which has been upheld by the Supreme Court, not only in appeal but in review as well?
Sir, Sadar Saab ने आपसे सिर्फ इतना सवाल पूछा है कि whether according to the law this judgment is to be considered a good judgment or not, or it is to be considered as affected by bias. If your lordships give your opinion that in our view, as per the law, it is affected by bias because of XYZ, that is all he asks. There is no more, even if your lordship sees the reference mein kahin ye nahi likha ki whether the judgment should be set aside or annulled or.
What about Davidson? What did you want? Which paragraph you want us to read?
Sir, ye tab 12 hai.
We've got it before us. Which, any particular thing you want?
Sir, the specific is.
What do you want us to see in here?
My lord, they say.
Acha, page 485 pe this marked portion.
Ji, sir.
The word bias.
Yes, sir.
Is a convenient shorthand, but it would be a mistake to approach it in this context as if its only meaning were pejorative. The essence of it is captured in the convention concept of impartiality. Is this a bit?
Yes, sir. This bit, and there's an earlier bit at paragraph 5, I think it is, sir.
हाईलाइट किए हुए आपने?
Page 4.
Paragraph 6. Sorry, paragraph 6.
Paragraph 6.
Ji.
And paragraph
478 pe.
47.
Ji, sir.
Cheek.
Where they say the expression is not a happy one since bias suggests malignity or overt partiality.
Mr. Salahuddin, we would love to read these judgments in the entirety.
I would just.
No. We would love to read these judgments in the entirety, but if you probably we will not because of so much work. So you'll have to specify this paragraph.
They are written, sir, paragraph 6 and 43.
कहाँ लिखा है आपने चीजें?
Sir, ये मेरे note में.
Okay.
Footnote पे I have put the paragraph.
Fine, then it's good enough. ठीक.
Sir, bias can be of two kinds, which Mr. Makhdoom Ali Khan had already pointed out, so I'm not going to belabor it, but there is the actual bias, which is sometimes referred to as bias in fact or subjective bias. That involves ascertaining the state of mind of the judge. And that is obviously a very difficult exercise. The more common type of bias is what is referred to as bias in law or objective bias, or sometimes as apparent or perceived bias. Now, in that, a judge may not actually be inclined or predisposed in a particular way, but a fair-minded and reasonable observer would conclude there was a reasonable possibility of the tribunal being biased. That is the latest test. That the case law has gone back and forth, etc. But this is the latest test. Ye, sir, maine footnote 22 pe I have put down the. And this is, of course, just another way of saying justice must be seen to be done. Now, in this particular case, sir, the fair-minded observer would have entertained the reasonable possibility that the tribunal is biased on account of at least 4 things that are stated by Justice Naseem Hassan Shah. Isme, sir, if your lordship can first look at the book and then at the...
So objective bias, according to you, would be bias which doesn't require further inquiry, and a reasonable man could suppose that there is bias.
Yes, and that your lordship can conclude as a matter of law, with no factual
inquiry is required for it.
Exactly, exactly. अब सर पहले किताब पे आ जाते हैं और फिर उसके बाद जो इंटरव्यू है
जी
किताब सर पेज tab 20 है. It's the second book, sir. Sorry, 21. Isme the relevant chapter I have included. If your lordship will see 666.
Sorry, can you repeat that?
Sir, 666. Tab 21.
जी 666.
666. And if your lordship sees the third line, I think part of it has already been read by Mr. Maktoum Ali Khan, so I won't take up your lordship's time. But in this, he says that Justice Mushtaq Hussain, Chief Justice of the Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, came to see me. Now, sir, the reason why this, and they asked me that I should sit in on the appeal. Now, the reason why this is not an allegation, at least I'm not using it here as an allegation that he made against Mr. Justice Mushtaq Hussain or Mr. Justice Sharifuddin Pirzada. But your lordship will recall that Justice Naseem Hassan Shah was himself hearing, and he was part of the bench that was hearing the bias of the Chief Justice of the Lahore High Court. Now, at the time, if the Chief Justice of the Lahore High Court, after having made a decision, comes to a Supreme Court judge and says that you should sit in on the appeal against my decision, now that is a relevant matter that Justice Naseem Hassan Shah ought to have disclosed at the time when he was hearing the Bhutto appeal. And especially when 90 paragraphs are devoted to the point of bias of the Lahore High Court.
So you're saying that when the meeting took place, Justice Naseem Hassan Shah was already hearing the matter?
No, he heard it subsequently, but he ought to have disclosed it not only to all his fellow...
Oh, this fact.
However, few days later, the Chief Justice informed me that the full court strength was 9, and he would like to keep this strength, and since I was the 9th judge, I shall have to sit on the bench for this appeal hearing.
बिल्कुल
ये reason दिया उन्होंने
जी
9 जज चाहिए थे, मैं आखिरी था उनका 9 जज का बेंच बना.
Salahuddin, before we come into the latter part of the thing, I mean, I think this is very inappropriate conduct for a Chief Justice to approach a judge of the Supreme Court to say, sit on the appellate bench.
Yes. It shows your personal interest in the outcome of the case.
This fact in itself, that's a lower forum coming to the high Supreme Court with the Attorney General and saying sit on the bench. I mean, I thought this in itself would be, this I think is more damaging than whether he should have sat as a ad hoc judge or not as an ad hoc judge. I think ad hoc judge's constitution makes it very clear as all the powers of a normal Supreme Court judge. So let's not go there. But why is nobody pointing out this fact that Mr. Justice Mushtaq Hussain, Chief Justice of Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, had come to see me. I went to the guest room to meet them, and after exchange of usual civilities, the point of the visit was explained. The point of the visit was their visit.
Yes.
They wanted me to sit on the appellate bench. So a High Court judge is dictating to the Supreme Court judge. I mean, I find
and he's
this
coming with the Attorney General of the time.
really, I find that amazing. I mean, you know, I don't know if this ever happening. I mean, sit on you. Please sit on my judgment and uphold it.
Had this revelation been made at the time, this would have been a completely independent ground for setting aside the Lahore High Court judgment. And additionally, what I am pointing out is
ایک تو یہ
that
point ہے,
this-
what is the additional point? Yes.
Additionally, what I am pointing out
لکھا ہوا
is,
ہے, یہ جو کچھ لکھا ہوا ہے, اس کو کیا کہیں گے؟ اس کو ہیئر سے ایویڈنس نہیں کہیں گے. اس کی کیا ویلیو کیا ہے؟ مطلب ریٹائرڈ ہونے کے بعد کسی کے بارے میں کہتے ہیں کہ وہ میرے پاس آیا تھا, اس نے مجھے یہ حکم فرمایا تھا.
میں اسی لیے
یہ ہیئر سے ایویڈنس میں آئے گا جب تک کہ اس سے کنفرم نہیں ہوتا کہ مشتاق سے یا دوسرے کسی اور سے.
سر اس پہ میرے دو پوائنٹس ہوں گے, اینڈ دس از دی ایڈیشنل پوائنٹ دیٹ آئی واز سیئنگ. دیر از ون, the weight of what Justice Naseem Hassan Shah has said about the Chief Justice of the Lahore High Court. Then there is the statement as far as he is concerned. Personally, he has made this statement. This is not hearsay.
On a technical point, was when this book was published, was Justice Musaq Hussain alive?
My lord, I do not know. I have not been.
You know the date of publication of this book?
Sir, جو title page تھا اس
اگر
پہ
کوئی یہ دیکھ کے یہ بھی ہمیں پوائنٹ بتا دے, بعد میں بتا دیجیے گا کہ ڈیٹ آف پبلیکیشن اینڈ ڈیٹ.
کا چانس بھی ملا یا نہیں ملا؟
2002 apparently, sir.
اور ان کا وہ کب تک زندہ تھے؟
At least Sharifuddin was present. He was alive.
Mr. Pirzada was alive. He passed away recently. I'm not sure about it.
9-member bench کوئی need of the hearing of appeal تو نہیں تھی نا سپریم کورٹ میں, 7 بھی ہو سکتا تھا.
جی
9 نہیں ہو سکتا.
جی میرا پوائنٹ جہاں تک جسٹس شاہ کے بارے میں تھا وہ یہ تھا کہ ایٹ لیسٹ ایز فار ایز دا وزٹ از کنسرنڈ, whether this was evidence against Justice Maulvi Mushtaq or not, it was, as far as he was concerned, it is admissible. He is saying that someone came to meet me now and asked me to sit on the bench. So this was something, when you were hearing the bias application in the Supreme Court against the very same judge, this was a judicial duty of Justice Shah to mention it to all the other members of the bench and to also inform the defense counsel.
But he didn't, not because of this saying of that he made himself sit on the bench. The Chief Justice of the time.
I'm not saying that he made himself. He should have, when he was sitting, whether he was rightly, wrongly included on the bench is a different thing. He was on the bench.
Disclosure.
He knows that an application of bias against a particular person is being made. A particular incident about that person which reflects the bias is in his knowledge. He was under a duty to disclose it to his brethren as well as to the defense counsel.
So you mean that he was influenced? He was
The fact that he did not do so is a fact that would cause a reasonable observer to conclude, to come to the possibility that the tribunal was biased. If he knew about this bias of the Lahore High Court Chief Justice and he kept it to himself, he rejected the bias application.
When was the bias application filed?
Sir, there are two. One was in an interlocutory stage.
Yeah.
Interlocutory stage पे उन्होंने कहा कि नहीं पहले आप ये ground नीचे जाके bias of the Chief Justice of Lahore नीचे जाके.
It will depend when did this particular conversation or meeting take place.
Yes, sir.
Because if we go by what you say, fine, that's बिल्कुल ठीक है, लेकिन वो depend करता है कि वो application कब आई थी, इस meeting से पहले या इस meeting के बाद.
जी सर. Sir, वो जो judgment है, because it was part of the final arguments of Mr. Yahya Bakhtiyar, and the judgment, it is mentioned.
नहीं, आप वहाँ ना आए ना. आपका contention ये है कि जज साहब को उस टाइम पे डिस्क्लोजर करना चाहिए था. ठीक है, वेल एंड गुड, बिल्कुल सही है, करना चाहिए था. अब बात ये है कि ये जो कॉन्वर्सेशन हो रही है, मे बी दिस इज प्रायर टू दैट, मे बी इट्स आफ्टर दैट. सो अगर ये पहले हुआ होता और वो बाद में आए, फिर बात बनती है, वो हमें कैसे मालूम होगा?
Sir, I will check exactly the date of the application, but the point I'm making is, at any time before the final judgment, he should and could have disclosed it, because the final judgment has about 50 pages that deal with the bias of the Lahore High Court. So at the time of rendering the final judgment, tab to ye वाकया हो चुका था, तो तब उसमें तो जिक्र करना चाहिए था और उससे डिस्क्लोजर भी हो जाता.
सलाउद्दीन सर
जी,
ये दो अफराद जो गए, द then Chief Justice of High Court and Mr. Sharifuddin Pirzada, asking Justice Naseem Hassan Shah to sit in that bench, whether that was their own request or they have conveyed the message of someone else.
We do not know. We do not
Because
know
the
from this.
Judge of the High Court going and asking the Chief.
There are other reports about this, but I'm trying to keep it because then factual inquiry की कहानी ना शुरू हो जाए, तो that's why I'm trying to keep it
लेकिन इसको जरा
confined.
आगे पढ़े ना, वो कहते हैं I told them that I was an ad hoc judge. ये पढ़े जरा.
जी sir.
He actually says
He is
this is
giving an
wrong.
explanation.
Yes. इससे पहले भी वो कहते हैं कि normally these kind of cases were never placed before. ad hoc.
So he qualifies it. पढ़े.
जी.
They wanted me to. You underlined it. They wanted me to पढ़ ले.
They wanted me to sit on the appellate bench being constituted to hear Mr. Bhutto's appeal in the Supreme Court. I told them that I was an ad hoc judge and it was therefore not proper for me to sit on the bench. I also felt that it was wrong
Now,
for my...
why would a judge of the Supreme Court give an explanation to the Chief Justice of a province? That means that they have conveyed the message of someone else.
Perhaps, yes, that is a reasonable conclusion to draw, yes.
I also felt
that it was wrong for my two guests, being interested parties, to broach this subject with me. They were fully aware of this situation, but still insisted that I must sit on the bench. I was not agreeable. However, after a brief discussion, I made it clear that I shall do as directed by the Chief Justice, knowing that the Chief Justice was a man of judicial integrity and these two worthies, in spite of their personal relationship with the Chief Justice, would not take this matter up with him. However, a few days later, the Chief Justice informed me that full court strength was 9 and he would like to keep me on this strength, and since I was the 9th judge, I shall have to sit on the bench for appeal hearing. Sir, apart from this, there is another aspect.
ये clarification तो दे दिया उन्होंने इसके अंदर, I think.
नहीं, but ये बात जरा उन्होंने जी.
Sir, मैं ये तो कह नहीं रहा, and it will go slightly into speculative कि वो bench में वो हिस्सा नहीं बनने चाहते थे, कैसे include किया गया, क्यों किया गया, Chief Justice साहब ने क्यों किया. मगर ये वाली बात जो लाहौर हाई कोर्ट के Chief Justice साहब का जो personal interest था केस का, वो और जिस चीज का उन्हें इल्म था, वो चीज नुमाया करना चाह रहा था.
उन्होंने क्या चीफ जस्टिस ऑफ पाकिस्तान को इन्फॉर्म किया कि मीटिंग के लिए आए थे ये दोनों हजरात मेरे पास?
We do not know, sir. It should have been disclosed to all the members of the bench, because your lordship will recall that 3 of the judges had disagreed. So perhaps if this fact had additionally come to the knowledge of all the judges, perhaps it could have been 4 or 5 who said कि नहीं रिमांड करके लाहौर हाई कोर्ट में दोबारा ट्रायल करवा देते हैं नए बेंच के सामने. That could have happened if he had disclosed this fact.
But he actually sets the standard, the bar. He says that the Chief Justice is a man of judicial integrity and they would not have had the dialogue with him. But
nonetheless it happened.
But they could have it with me.
Sir, एक दूसरा aspect है जो इनके memoirs से सामने आता है, and ये page 669 पे है. This is about the negotiations that were conducted by him to reduce the sentence from death to life. ये sir 669 पे है. And this is relevant to the factor of extraneous considerations. Any consideration, bias can be any extraneous consideration. If your lordship will see 669 pe second para, I can now tell for the first time how the Chief Justice and I made an attempt to save Mr. Bhutto's life. Again, it is the Chief Justice and I. He's personally taking responsibility. With 4 judges hailing from Punjab, apparently in favor of upholding the judgment of the High Court, convicting Mr. Bhutto and sentencing him to death, while the remaining 3 judges being of different viewpoint, the responsibility and strain on the shoulders of Chief Justice Anwarul Haq was overwhelming. Being a patriot to the core, he was deeply distressed and disturbed by the news reaching him to the effect that in case the court decided to hang Bhutto, a very negative impression would be created. in other provinces, especially the province of Sindh. Speculation was that in such an event, the rift between the provinces would become difficult to reconcile and they would not be able to work in harmony in the future. A disastrous scenario was painted for the unity of Pakistan. Such a situation, Anwarul Haq, Chief Justice, considered very serious and was so keen that it should be avoided if humanly possible. After giving deep thought about how to handle this difficult situation, wherein demands of justice should be met, but at the same time the catastrophic effects on unity of federation may be averted, he conceived a device which he considered might salvage the situation, and I was chosen by him to play a role in the implementation of this device. He knew that my relations with Justice Durab Patel, puisne judge of the court, were very cordial, and throughout the hearing of the case, I had not expressed myself in categoric terms or given any definite view on any aspect of the case. Indeed, journalists reporting the case had repeatedly written that my final views could not be deciphered. Consequently, it was suggested to me that I might have a detailed talk with Justice Durab Patel regarding the case and the general situation in the country. Being the senior-most judge of the faction favoring the view that Mr. Bhutto was not guilty, he was in an ideal position to handle the situation. The proposal put forward by Anwarul Haq, Chief Justice, was that a unanimous verdict may be handed down by the court so as to obviate all provincial acrimony. According to him, the fairest solution would be if the Punjab judges could be persuaded to agree to award a lesser sentence to Mr. Bhutto, thus saving his life, while the pro-Mr. Bhutto judges might agree to hold him guilty of the death of Nawab Ahmed Khan. Being of the same view and eager to save Mr. Bhutto's life, who had been very kind to me personally, and then he goes on to say, I readily agreed to approach Justice Durab Patel. This is in fact, the meeting with Justice Durab Patel is in fact corroborated by Justice Durab Patel himself in his interview, which Makhtoom Saab had also referred to. But the point is, even the consideration of provincial acrimony in the verdict, that is an extraneous consideration. This is an extraneous consideration that is admitted to by Justice Naseem Hassan Shah when he says that I went to negotiate on this platform.
This shows impression that the judges are deciding cases on the basis of their area, their provinces.
Yes, on basis of political consideration.
Is this not a bias?
Yes, that is the case. That is the case. Now, after this, sir,
complainant belongs to which province?
Sorry?
Complainant belongs to which province?
Complainant belongs to Punjab as far as I know, sir. Now, sir, jahan tak interview ka sawal hai, there are a couple of things that I would point out.
Is it a confession? Is it an admission? Is it correcting the historical record? What do you make of this memoir? What do you make of it? Your personal opinion?
These statements are admissions, prior admissions in writing, adverse to the interests of the person making. If it was a court of trial even, these admissions could be admissible under Article 46(1) and 46(3), I think it is, of the Qanun-e-Shahadat. These are admissible statements. But over here, that is not the standard that your lordships are to apply. Your lordships are not sitting as a court of factual inquiry. Over here, the test that your lordships are to apply is, as a matter of law, is that what would a reasonable observer of judicial proceedings, what conclusion would he draw as to the safety of the proceedings after these revelations were made in front of
we go back to due process and fair trial.
Yes.
So this paragraph that you've read, 669 onwards, what do you draw from this? I mean, what's the conclusion?
जो 669 onwards है sir, उसमें ये है कि he admits that he was prepared, he was trying to change the verdict on the basis of considerations of provincial acrimony. That, with respect, is a non-judicial consideration. It is an extraneous consideration, and a judge cannot refer to these things while coming to a judgment and negotiating with a fellow judge.
Well, he was influenced from that the repercussion may be so that it cannot be controlled, therefore lesser punishment की तरफ हो जाना चाह रहे थे.
बेशक, but it was not permissible.
वो तीन मान नहीं रहे थे और ये तीन
This is the dialogue that takes place between judges. This is how one should do, or this will have this implication, then they could settle somewhere else.
My lord, I have not had.
Yes, that's right.
इसका डिस्क्लोजर किस हद तक करना चाहिए नहीं करना चाहिए ये तो परसेंट वेरी है ना.
नहीं देखिए, I think this sort of dialogue at least hasn't ever happened with myself. What you, once it is ascertained, there are two aspects to a criminal trial: guilt or not guilt. And if there is guilt, then comes the punishment. How much? In matters of punishment, of course, you can discuss. Yes, this case is so horrendous, maximum punishment, or not really. It could be in a theft case. There are all these things have variations. You can see whether it's CNS, whether you have drugs. In matter of murder, there are only two punishments: life or death. So yes, but the negotiation aspect could be, or the discussion aspect could be on the part of either you try to persuade each other that their other person is guilty or not guilty. But the other negotiation can only be on the matter of the punishment part. And it's always, generally the settled rule is that even if one is inclined towards lesser punishment, you go with that view. I mean, I don't know, that's kind of, I think that's the approach. Even in bail matters, that if three judges, one thinks that's a bailable matter, then you go with that view rather than reject it by a majority. I don't know. I thought these are the principles we have evolved. What is your opinion?
Sir, jo Indian law mein...
नहीं, आपका opinion बताएं.
In my opinion, the verdict should be unanimous in case of death. If the verdict as to guilt is not unanimous, then death sentence should not be awarded because you can never bring back a life.
और ये जो डिस्कशन आपने पढ़ी है उससे भी यही लगता है कि सब उस पर शायद एग्री नहीं थे कि इट इज ए केस ऑफ कैपिटल सेंटेंस.
Sir, punishment के ऊपर permissible, technically speaking at least, and bowing to what Justice Mansoor Ali Shah has also said, but technically speaking, at least the only points of negotiation could have been how heinous was the case, whether what was the past track record of the accused, so and so, etc. Those were the only permissible judicial considerations. The political impact of it, strictly speaking, is a non-judicial consideration. It is an extraneous judicial consideration. I do, of course, although the traditional saying is let justice be done, but the heaven, even though the heavens fall. But I do realize that sometimes practical considerations are discussed.
But I'm sure you've read books from American judges who talk about, they go out for lunch together, they try to convince each other, there's a lot of dialogue going on. They very openly write about it in their books. So, and then it could settle elsewhere, it could settle somewhere else.
Fair enough, I'll move on to my next point, sir. The interview, sir. Sir, ye interview ka, agar aap page 7, type page 7, interview is at tab 20. And iska type page 7 jo hai, that is $655. Itself is a little vague. I'll point out from the beginning. What it does say is that the relevant bit is middle of the page, Iftikhar Ahmed. Sir, ye Bhutto ka, Zulfikar Ali Bhutto ka historical case hai. Main Journal...
ये page कौन सा है?
655. जी. Journal asar andaz hue the. That is Iftikhar Ahmed's question. And then Justice Shah answers, नहीं मेरा नहीं ख्याल असर अंदाज, हमें तो किसी ने नहीं कहा کہ اس طرح فیصلہ کرو اس طرح فیصلہ نہ کرو. ہو سکتا ہے اینڈ دس از دیٹ از ہو سکتا ہے چیف جسٹس سے وہ بات کرتے ہوں اور تھوڑا بہت انڈائریکٹلی ہم سے کہتے ہوں کہ اس طرح کر لیا جائے تو بہتر ہے.
اس کا کیا مطلب ہے انڈائریکٹ مطلب ہاں
This is, I'm just pointing out, I'm not...
what do you understand by it?
My lord, the implication is that nobody talked to me. They might have been talking to the Chief Justice who indirectly conveyed it to me. But that is an implication I'm not going to draw.
آگے بھی پڑھنے ذرا.
جی سر.
لیکن میں 26 سال سے یہ بھی پڑھتے ہوں.
لیکن میں 26 سال سپیریئر کورٹ کا جج رہا ہوں. مجھے ایک دفعہ بھی یاد نہیں کہ کبھی کسی نے ہمیں کہا ہو فیصلہ اس طرح کرو اس طرح نہ کرو. یہ جج جو ہیں وہ خود ہی ڈر جاتے ہیں کہ ہم نے پتہ نہیں زمینیں لی ہیں زمینیں لی ہوئی ہیں ہمارا بیٹا ملازم ہے ہمارا یعنی اب کنفرمیشن کا مسئلہ آ رہا ہے تو ہمیں فوجیوں کو ناراض نہیں کرنا چاہیے.
جنرلائز
باقیوں کے بارے میں
جنرلائز بات ہے جنرلائز بات
talking about the others, not himself.
ہم کی بات کر رہے ہیں وہ.
but he speaks specifically about the Chief Justice, at least in vague terms, but I'm not. The more important...
It is vague and you are referring next time اس کی commentary آپ بنا کے.
سر دوسرا پیج جو امپورٹنٹ ہے اگر آپ پیج 8 ٹائپ پیج 8 this is the next page sir.
پیج کیا ہے
سر پیج 656 اور اس کا about the 10th line from the bottom. تو صاحب یہ جو جب میں اگر میں مجرم ہوں میں اکیوزڈ ہوں میں کہوں کہ مجھے آپ پہ اعتبار نہیں مجھے آپ سے انصاف کی توقع نہیں ہے تو آپ بطور جج کیا کرنا چاہیے. Now اس میں پھر then he goes down the second last question. افتخار احمد مولوی مشتاق صاحب کی میں بات کر رہا ہوں. مولوی مشتاق صاحب کو ذوالفقار علی بھٹو نے یہ کہا. جسٹس نسیم حسن شاہ جی ہاں اور میرے خیال میں مولوی صاحب کی زیادتی تھی کیونکہ وہ بہت یعنی زبردست آدمی تھے اور وہ بھٹو کے دشمن تھے اور ان کو چاہیے تھا کہ وہ اس کیس میں نہ بیٹھیں تو بہتر تھا. Now, if this was his view that Justice Maulvi Mushtaq was the enemy of Zulfikar Ali Bhutto, in that case again, while sitting on the bench in the Supreme Court, he should have come to a different conclusion.
خیالات کا اظہار تو ان کو اپنے ججمنٹ میں کرنا چاہیے تھا. نوٹ کر لکھتے اس میں.
لیکن انہوں نے کہا کہ ججز ذرا وہ اس وجہ سے کچھ ذرا کی وجہ سے رہ گئے نہیں کر رہے.
نیکسٹ بٹ سر یہ پیج 9 ہے ٹائپ پیج 9 657 پہ
میٹیگیٹنگ سرکمسٹانسز پہ آرگیومنٹ کا بھی لکھا ہوا ہے کہ
جی اس پہ ہی آ رہا ہوں سر. میٹیگیٹنگ سرکمسٹانسز جی
کہاں سے پڑھنا
جی سر فرام دا ٹاپ. سر آپ نے ایک جگہ پر اپنی رائے کا اظہار کیا. آپ نے کہا کہ بھٹو کیس کی سماعت کے دوران میری یعنی آپ کی ذاتی رائے تھی کہ بھٹو کی سزا میں کمی ہو سکتی ہے. جسٹس نسیم حسن شاہ جی اور اس سلسلے میں ان کا کیس بڑا مضبوط تھا. ہاں بالکل. So he concedes that as far as that was concerned his case was very strong. پھر آگے سر افتخار احمد آس تو جج صاحب جب آپ کنونس تھے جو آپ فیصلہ دے رہے تھے تو ڈسینٹنگ نوٹ نہیں آپ کو لکھنا چاہیے تھا اس حد تک کہ سزا نہ دی جائے. جی ہاں ہو تو سکتا تھا مگر جب وہ جو ان کا وکیل ہے وہ کہتا ہے مجھے سزا کی کوئی پرواہ نہیں مجھے تو اکویٹل چاہیے تو چاہیے میں سمجھتا ہوں بھٹو یعنی جو ہے وہ سر آپ بھی ڈسینٹنگ نوٹ تو دے سکتے تھے. جسٹس نسیم حسن شاہ دے تو سکتا تھا مگر یعنی میرے خیال میں اس میں کچھ تھوڑی سی ہماری بھی کمزوری تھی اور کچھ اس کی یا بختیار کی بھی تھی، یعنی ضد. اس نے ہمیں ایک قسم کا ناراض کر دیا. Now, one, he is conceding to weakness in not dissenting. The second, he is attributing it to the annoyance created by the counsel for the accused. Now, obviously, that is something, whether and particularly in a death sentence case, whether the counsel of the accused is annoying or not, what he argues or what he does not argue, the judge has to apply the law and the facts on the record.
The litigant should not be punished because of conduct of the lawyer. I mean, that's basic, and even in every civil case, I mean, you may be faced with an obnoxious, let's say, a counsel, but that doesn't mean that the litigant should suffer as a consequence.
And in a death sentence case, sir.
اگر وہ annoyed
In
نہ
any
ہوتے,
case, I would say.
In any case.
اگر وہ annoyed نہ ہوتے تو یہ دوسری طرف چلے جاتے اور
شاید عمر قید کی سزا ہو.
عمر نہیں بلکہ acquittal
جو کہہ رہے ہیں acquittal بھی ہو سکتا تھا.
Acquittal بھی ہو سکتا.
لیکن یہ بات بالکل غلط کہہ رہے ہوں کہ انہوں نے آرگو نہیں کیا. یہ 1979 کی دیکھیں 807 پہ 174 پیج پہ اسپیسیفک لکھا ہوا ہے کہ یہ بختیار نے یہ آرگو کیا کہ یہ میٹیگیٹنگ کا کیس ہے.
یہ کون سا
پیج 174 سر؟
جی جی نہیں پیج ہے 807 پیرا 174.
جی
ذرا پڑھیے اس کو. اگر یہ بات وہ غلط لکھ رہے ہیں تو کیا گارنٹی ہے کہ جو کچھ باقی کچھ فرمایا انہوں نے وہ بھی صحیح ہوگا.
یہ کمشنر پنڈی والی انٹرویو لگ رہی ہے.
اس میں دیکھ لیتے ہیں 807 پہ آئیے نا.
سر does your lordship have the SCMR کی citation یا سپریم کورٹ کی؟ I have PLD 79
PLD 79
سپریم کورٹ 53
سپریم کورٹ 807 پہ آئیے نا. 807 پہ آئیے.
سر یہ میرے پاس ہے, I'm sorry. جی اوکے
807 174 پڑھیے.
جی یہ شاید بات یہ ریویو والی جج.
ہاں 174 پڑھیے نا.
174. We may now deal with the last submission made by Mr. Yahya Bakhtiyar that in any case, even if the conviction of the petitioner is maintained, it is a fit case where lesser penalty should be awarded for the offence falling under section 302 of the PPC, read with sections 109 and 111. Thereof, for the reasons that the petitioner is guilty only of abetment and was not present at the spot at the time of the murder, that the conspiracy was to kill Ahmad Raza Kasuri and not his father who was hit by accident. That the conviction of the petitioner is based on the evidence of approvers. There has arisen a difference of opinion between the learned judges of this court as to the petitioner's guilt. That with the introduction of Islamic laws in country with effect from 12th Rabiul Awwal, it would be anomalous to impose death penalty for unintentional murder, especially when Shariat laws do not recognize an approver. And the witnesses have to fulfill strict qualifications as to integrity and character before the testimony can be acted upon, and that the fact that the petitioner was compelled to boycott the proceedings in the trial has also a bearing on the question of sentence. Now 175
جو کچھ بھی یحییٰ بختیار نے کہا یہ سیٹل پرنسپل ہے میٹیگیشن کے لیے, ہمیشہ کنسیڈر کیے جاتے ہیں فوجداری لا میں. کبھی بھی ایسا ہو تو ہمیشہ کنسیڈر کیے جاتے ہیں. تو یہ تو ہے وہ جو جج صاحب فرما رہے ہیں کہ کسی نے آرگو ہی نہیں کیا.
اگر آپ اگلا پیرا پڑھ لیں 175
پیرا 175 میں
جی, we find that none of these questions was raised by the learned counsel during hearing of the appeal. Although all these factors
is not required to even.
کہاں ریکوائرڈ ہے یار.
سر تو انہوں نے ڈیورنگ دا مین اپیل آرگیو نہیں کیا تھا, جس سے ججز کی طرف سے کچھ ناراضگی ہوئی.
وہ پوائنٹ تو ریویو میں بھی لیا جا سکتا تھا, یہ کوئی ایسا ایشو نہیں تھا.
تھوڑی ہماری بھی کمزوری تھی لکھا ہوا ایسا پنشمنٹ کا کوئی ایشو نہیں.
Now, my lord, the question was raised about the weight that is to be given to Justice Shah's revelations. I'd already pointed out and it's the citations are also there, para 9 of my statement.
रिटायरमेंट के कितने दिनों बाद किताब लिखी थी इन्होंने?
Sir, 2002 में तो it is probably about 10 years.
This interview is
About 10
2003.
years. जी.
हमारे सारे लोगों को रिटायरमेंट के बाद इनका ज़मीर जागता है, वो कुछ कुछ कहना शुरू करते हैं, पहले तो कुछ नहीं कहते.
ये भी जरा सा
Sir,
अब इनके ये दो स्टेटमेंट्स आगे, दो एक तरफ जजमेंट है, दूसरी तरफ बुक है, तो किस पे रिलाई करें?
Sir, I'm not saying that his book should also be relied upon. I am saying that his book has raised a reasonable possibility in the minds of a neutral observer.
To the extent that he condemns himself.
Yes, to the extent that he condemns himself, not anyone else. Now, jahan tak weightage to be attached to a book for these kind of statements is, my submission which I had made was that as per Article 46, 1 and 3, even in a trial, these would be admissible against Justice Shah. But in these proceedings, this court does not have to apply the standard of a trial. A somewhat similar situation arose, if your lordship will recall, in the dissolution of assembly cases. Over there, the question was that there were certain newspaper reports, etc., that was not to be relied upon.
Which period are you talking about?
Sir, jo 90s ke dissolution of assembly ke cases the. And lastly, in Benazir Bhutto versus Federation of Pakistan, PLD 1998, Supreme Court, page 388.
Gee, what was the point you're making?
The point that was, the distinction that was drawn there was that these newspaper reports are not being relied upon as per the absolute truth or otherwise of these reports, as would be done in a criminal
There is
case.
also a judgment that unless denied by the other party, these are the admissible.
जी बिल्कुल बिल्कुल उसमें distinction ये draw की थी that over here we are merely gauging whether the president has reasonably formed his opinion under Article 58(2)(b). And the president is required only to, he is not required to form an opinion on the basis of strictly proved evidence as required by law, but as a person of ordinary prudence would conclude. So if a person of ordinary prudence would conclude these newspaper reports which had gone unrebutted, that reliance could be placed upon them, so the president was justified in reaching that conclusion. Now over here, your lordship is required to put yourselves not in the place of a reasonable president, but a reasonable